Hi, Northwood University Business Law 1 class. I just wanted to say hello, and we're going to go over Chapter 2 pretty quickly. There's only about 30 slides in this chapter, but it gives a good overview of the legal landscape we're facing, businesses face, and we as well. I'm not sure how much knowledge you have about the court system or if you've been involved with the court system in any way. I mean, a lot of people do go through um, disputes at some point in their life, so they find themselves in court in one way or the other, or there's a multitude of reasons why someone would be in the court system. So um, I would love to know if any of you have some of that background in the introduction that I posted on for the discussion board. So please let me know a little bit more about you in terms of your background, how much knowledge you have about courts and also alternative dispute resolution. That's what we're going to go over today, and it's just a very basic top level look at how the courts work and where you would file a case or controversy and how it would lead up to the highest court, which is the U.S. Supreme Court. So I'm going to screen share my screen here. All right. So like I said, this is week 1, and we're going over chapter 2. So each week we have 2 chapters we're going to discuss, and then there's 2 assignments every week for the note-taking assignment where you'd have the main themes, and this is the 2nd chapter. But we're going to go over the courts and alternative dispute resolution. So what is judicial review? We're going to go over that in this chapter. Before a court can hear a case, it must have jurisdiction. So we're going to figure out where to file a case, or at least give you some background to the different court systems, so you have more information, and so you can understand the difference between a state court system and a federal court system. There's different requirements to get into either. So also, how are the courts applying traditional jurisdictional concepts to cases involving internet transactions? We're not really going to go into that too in depth, but we're going to definitely look at how to get into federal court, because state court has general jurisdiction over all cases. The hard part is getting into federal court. We're also going to look at the difference between trial court and appellate court. Also look at discovery and how discovery works a little bit. Just touch it briefly, not go into depth there as well, because discovery is a very it's pretty straightforward, but it's also the longest part of what cases go through. And also we're going to look at 3 alternative methods for resolving disputes that more companies are taking advantage of, because to be honest with you, it's so expensive to go to court. Not only attorney's fees, but time, money, waiting on a decision from the judge. Most cases don't go to trial until 2 years after you file a complaint, which is a long time to wait for any kind of resolution of a disagreement. So to introduce you to this subject, we're going to look at some interesting basics around the legal system. So the reason why we're looking at this is because business people like as yourself need to have an understanding of the court system in the United States, as well as various methods of dispute resolutions that can be pursued. A lot of these alternative dispute resolution methods are less expensive, and they also give clarity of choice for the business, because I don't know if you've seen in the media, but juries are really not predictable. It's a bunch of random people put together to decide something that could be worth millions of dollars sometimes. So businesses don't trust juries generally, and they either want to settle the case or they want to do an alternative method to resolve it. Because some of these alternatives use people who have been judges or who are lawyers themselves to decide cases. So they may favor businesses or understand legal arguments a little bit better than juries, because juries are known to be unpredictable. They may have their own biases. I mean, they're a collection of 12 people that may or may not understand the case. Sometimes cases can be very complicated if they have anything to do with chemicals or someone stealing, ideas from another individual and explaining really high, in-depth concepts. So most attorneys say that businesses really like to settle cases before it going to a jury. I think 90% of all cases get settled out of court without a official trial. So also keep in mind, there's also a thing called a bench trial. A bench trial is when a judge acts like the jury and decides the case on behalf of the jury. You can decide whether you want a jury or just a bench trial. Most plaintiff attorneys who sue on behalf of an individual who's been injured or one person who's been aggrieved for employment discrimination, for instance, they like jury trials because they tend to favor the individual over businesses. So there are a lot of strategic reasons lawyers pick certain ways of going forward with a case. You won't need to know that, but it's good to have kind of a background. So if you are involved with any kind of litigation or business decisions that could impact anyone negatively, or you think may cause blowback with the business, you know there's options and what the options are. So we're also going to clarify judicial procedures and examine the court systems of the United States, as I said earlier. We're going to figure out where to sue, whom to sue, cause of action for a lawsuit, and what the amount of damages or the amount in controversy is. Well, really, we're not going to decide that, but you just need to know those four concepts. So if heaven forbid you get injured on the job, or you have a issue with your business, you will have a somewhat idea of where to sue, whom to sue, what kind of cause of action you may have. These are all concepts that your attorney will help you with, but it's good to have this in the back of your mind for business purposes. There's also the amount of damages means how much you've been aggrieved. So let's say you get let go for illegal purposes. Someone doesn't like how you look, and you're in a protected class of citizens, or even if you are not, and they are, letting you go for gender or other reasons. You need to know, how much you could probably get in court if you take that company to court. And that's what the amount of damages means. So the judiciary's role is to interpret the law and to apply it to your case. That is the basic idea behind a judiciary. It's trying to resolve conflict and decide based on the rule of law. Through the judicial process, judicial review is determining the constitutionality of laws. The judicial branch acts as a check on the executive and the legislative branches of government in the federal court system. So the state court applies a lot of state court laws, and the federal court usually applies federal law. They also apply other state laws if there's amount in controversy. met, which is 75,000, and the two people in dispute are from different states. So we're going to go over that a little bit in a second. So the basic requirements and the basics before a court can hear a lawsuit, they must, the jurisdiction must be correct where you file your lawsuit. It should be the correct place. The correct court should hear the case in controversy. The venue should be correct, where the actual court is located. And you must have a injury that can be resolved by that court. And that means you need standing to sue based on some issue. If you weren't injured yourself, you can't really sue for another party. So if you see someone else this is a personal injury type of situation. If you see someone else getting hit by a car, you can't sue on behalf of that other person. You yourself have to be the injured party. And that's what standing really means, is that you were injured and you have standing to sue. Before a court can have the authority to hear a case, it must have jurisdiction over one of these three things: a person against whom the suit is brought, or the property involved in the suit, or the subject matter. So jurisdiction just means they have the ability to make a final decision on the parties and case in controversy. So they need one of these three things. There's basic judicial requirements that include these 4 different points. There's limited jurisdiction, where a specific subject matter such as divorce is decided. You can't bring any kind of case to that court. You can only bring a divorce situation. That's what limited jurisdiction means. It's a limited, it's a body that has limited decision making. There's also family court that decides custody battles and has custody issues that come up. That's also a limited jurisdiction court system. There's general jurisdiction, which means that any kind of case can come to that court. Most state courts have general jurisdiction. Circuit court, state circuit courts generally have general jurisdiction. There's Oakland County Circuit Court, and there's Wayne County Circuit Court. There's other areas, other counties that have their own circuit courts. And then there's original jurisdiction, where they hear a case for the first time. It's the trial court level, so usually it's the district court or circuit court. I had the pleasure of going to district courts, which is in each city, they have a district court. So for instance, they name them by number. So there's like 43rd District Court. Each little town has one. So for instance, Rochester Hills has a district court, and Clinton Township and Midland has a district court. But we're all from all over the place. So I don't want you to think I know every district court, but they're all numbered generally. And those are usually trial courts systems where they can hear any case. And if the case is at a certain monetary level, you would file the case not in district court, but in circuit court. This is state circuit court, and they decide cases that are worth more money generally. And they are also a general jurisdiction court. You have to have certain requirements to get your case into that court as well. But they are also an original jurisdiction court. And then there's an appellate jurisdiction. It does not have original jurisdiction. It's a court of appeals type court. So if you had a case go to trial in district court, for instance, and you had the trial decided, if you wanted to appeal that decision, you would take it up to the circuit court in your state. They have appellate jurisdiction over all district courts. So I had one case was decided in district court for my party. Well, the person who was sued appealed it up to the circuit court level. She did not have an attorney help her with the appeal, unfortunately, and she didn't realize she didn't have a good case. But the circuit court decided against her and for me, so she could never appeal that decision. It was basically everyone has the right to appeal a trial court's decision if there's something to appeal. But in this case, she lost in circuit court. So there's different ways to appeal a decision, and so it's just good to have this knowledge that it would go up to the next level of court system. Okay, so there's a federal jurisdiction as well. Federal jurisdiction is difficult to reach in a lot of issues that come up. For businesses, though, I believe it's a lot easier because usually there is a diversity of citizenship. So this is the rule that to get federal jurisdiction, you need one, it needs to be based in part on the US Constitution, a treaty, or a federal law. Or the other way to get it into federal court is to have number 2, diversity of citizenship, which means they're citizens of different states. Businesses are the citizen of where they're considered they're located, or where their registration is. So I'll go through that a little bit more, but for people, it's very easy. It's wherever they're citizens of different states. But they also must have the amount in controversy exceed $75,000 to get in court. So if there's 2 people or 2 companies that are from different states, and the amount of controversy is $50,000, let's say a breach of contract, they can't bring it into federal court. They have to bring it into a state court system. So I will explain it more. Well, this explains it more to give you a visual overview. This goes over federal subject jurisdiction, number 1 in the last slide, to really explain it and give you a visual of how subject jurisdiction works. So here's the YouTube clip. Just take a look at that. I'm going to post this after I finish this presentation. Also, number 2 is diversity jurisdiction. This gives a really good overview of how to satisfy that to get into federal court. If you don't satisfy either of these, number 1 or number 2, the case will be dismissed. So once you file the case, either the judge or the other side will file a motion to dismiss the case, saying it doesn't have proper jurisdiction. So what that does is just causes you more headaches and more time to file it somewhere else. So usually an attorney wants to make sure they file it in the proper place. So these are very important concepts to save money and time. So there's some courts that have concurrent jurisdiction when there's 2 different courts that have authority to hear the same case. If there is a case in controversy that is worth $50,000 and it's from 2 different residents of different states, you could either file it in the state where the one resident lives or the other resident. So there's 2 different states that could potentially hear the case. It's up to you where to file it, though. There's a lot of reasons why you would file it in one state over the other, whether it's a more liberal state or a conservative state, depending on who your party you represent, the businesses or the party you're representing is. So that would be all strategic thinking. But there are concurrent jurisdictions that occur where 2 different court systems could hear the same case, and you have to decide where to file that case based on many factors. There's also exclusive jurisdiction when only one state court or only federal court has the authority to hear a case. For instance, there are cases that have US constitutional issues, and usually those cases have the exclusive jurisdiction lies in federal district court because it's a US constitutional issue. So for instance, what's in the media right now is all the voting allegations of fraud, and those were all filed in federal district court because there's it's all based on actually it might have a lot of state law involved too, because voting is a state court or states right issue. So I'm not really sure, but I'm trying to give you an example. I will think about it and get back to you. So there's also venue, the most appropriate physical location for a trial. If your business is located in Delaware, for instance, and the other business is also located or registered in Delaware, a court may dismiss a case if you file it in California and say, no, you should go to Delaware instead because that's the most appropriate place. There's also standing to sue. Like I said, the party must have sufficient stake in the matter to justify seeking relief. Like I said, if you watch someone get hit, you can't sue based on that person getting hit. You need standing, you need an injury, and you need a sufficient stake in the matter to justify that you're bringing the case. It's really two people or two companies having disputes with each other. If someone's doesn't really care one way or the other how the case goes, you can't bring that person as one of the people suing. So the state and federal court system includes 52 court systems, one for each of the 50 states and the District of Columbia and a federal. Generally, any person who is a party to a lawsuit has the opportunity to plead the case before a trial court, and if he or she loses, before at least one level of the appellate court. Kind of went over that a little bit earlier. So the state court system includes trial courts of limited jurisdiction. Like I said, family law is a big specialized trial court, limited jurisdiction court system. A lot of divorce cases come to a family court system. They do not hear any other kind of cases. Also, custody cases for children, they go to a family law court system. There's also business court for circuit courts. So only business cases would go to that court, and they have a limited jurisdiction. But there's also trial courts of general jurisdiction. They hear any and all cases. That's usually the district courts, but also the circuit courts have a system where they hear everything, any kind of case. So that's why the circuit courts tend to be the most busy courts in Michigan, at least. And then there's appellate courts. And then each state has the highest court, usually called the state Supreme Court. Michigan has a state Supreme Court. So here's Exhibit 2.2, just to give you an overview of the different court systems. I remember when I was in law school, I had a Michigan map of the different district courts, circuit courts, and federal courts, because they all have different outlines of where, if your case happened, you would file it in that certain court system. So it's good to know that there's different jurisdictions and different locations you would file a case. There's also the trial court level. They're courts of original jurisdiction. Legal actions are initiated usually in the trial court level before you appeal anything. This is where trials are held and testimony is taken. It's also called county, district, superior, or circuit courts. So we have a district court system, which is all numbered, and then we have a circuit court system, which is also all numbered. So for instance, I did a lot of work in Detroit. That's the Third Circuit Court, and that's one of the busiest courts. For some reason, they have a lot of cases. Also, there's Oakland County has a circuit court, and Macomb County. Those were the three I attended the most. District courts are all, like I said, all over the state as well, and each city usually has a district court. Then the appellate courts, there are courts of appeal when you're appealing a decision by a trial court. It's a reviewing court to make sure the decision was correctly made. They don't have original jurisdiction or conduct trials. So they only review evidence that's been presented already. You don't present evidence again. You don't do discovery again. You just have a review of a decision at the trial level. They always focus on questions of law. They don't focus on questions of fact. So questions of law are usually whether this evidence really supports, breaching this issue. They don't go over all the factual information. Again, they assume that it was decided, or it was presented correctly. So just keep that in mind. The federal court system has a three-tier model. They have U.S. district courts, and these are trial courts of general jurisdiction, and they have various courts of limited jurisdiction. They have a U.S. Courts of Appeal, and then after that, it's the United States Supreme Court. So this is the map that I was, one of the maps that a lot of lawyers will keep in their offices just for federal court. These show all the different federal court jurisdictions. We're in the Sixth Circuit. As you can see, Michigan is right there. So any case that comes out of Michigan goes to the Sixth Circuit, the Sixth Federal Circuit. And our federal circuit is in Detroit. I know we have one court there. I'm technically every attorney has to get barred to go to in federal court, and I've been barred to enter federal court. It's a pretty simple process once you get your bar exam results and you pass the Michigan bar, but they're located in different areas, the federal circuit court systems. But this gives you kind of an overview. So to follow a state court case, these are the different words we use when we file things. There's a pretrial procedure, which includes the first thing you do is you enter, let's say you're going to circuit court, the state circuit court. You file pleadings, which is the complaint usually. The complaint explains exactly what the business did incorrectly and why your business is suing that business. And then a summons is when the court gives just like a form document that says the business you're suing must reply to your complaint within a certain amount of time. And so that's what a summons is. It's a way to serve your complaint on them officially and to notify the court that they did receive your complaint. You know how you see people giving summons and complaints to people, process servers, if you've ever seen any movies or you've been served yourself. Process servers are summoning that other party to come to court or to answer the complaint against them. So then there's a defendant's answer. It's the response to the complaint that to explain whether they're right or wrong. Usually it's pretty a form letter type response, just saying, I do not agree with this. I do not agree with this over and over and over again on each of the points that a complaint has. And then there's pretrial motions that either party can file after that point. You can include a motion to dismiss, which means this has no weight and it should be dismissed because lack of, legal reasoning behind it or lack of evidence or whatever. There's a multitude of motions you can really file. You can ask for a motion for summary disposition, or it's also called summary judgment, which means they don't have enough evidence or they don't have the legal position to to win this case. So you should dismiss this case on what has been given to you so far. Then there's motions to leave out evidence. I remember filing those. If the one party thinks some evidence is wrong or not bound in fact or lacking credibility of some sort, you can file a motion to leave out that evidence. So that's during discovery. It's when you gather information, including witnesses, documents, and records. Usually discovery lasts quite some time. The judge will give you an amount of time when there's active discovery, when you can request information from the other side, and the other side requests information from you. However, I want to point out that during discovery or a little bit past discovery, usually 90% or more of the cases settle before going to trial, because after discovery, you can even do depositions of witnesses, depositions of doctors, depositions of the plaintiff who has been injured, depositions of business owners, if there's a business disagreement. After those depositions, and usually they're quite expensive, like I said, 90% or more of the cases are settled. So why do you think that is? I would love to hear your thoughts. But really, because this is an online class, I can't get your thoughts. So I'm going to just tell you, it's because usually the evidence is pretty either understandable at that point, so a trial would be unnecessary, or because one or both parties don't trust a jury to really conclude in their favor. So a lot of people don't trust juries to really understand the facts and to decide in a understandable way why they're just, no one can trust what they're going to do. For instance, I remember there was a Jeffrey Feiger case that I heard about when I was working in birth trauma defense, and the jury awarded way more money than what was allowed under the law. They thought Jeffrey Feiger made a really great case. If you don't know who he is, he's a plaintiff personal injury attorney who usually represents people injured by companies or even by hospitals or by doctors. And the jury awarded this one plaintiff a ton of money, more than anyone has ever seen. I think it was like $250 million. And there are limits to how much a person can get in terms of personal injury. So even after the judge told the whole jury that you can only award $5 million at the most if you find that the hospital committed malpractice, they still awarded $250 million even after hearing that. So that's one example to show you that the jury is not always listening to every piece of evidence or either listening to the judge. So you'll see that a lot of cases get settled. So a state court case goes to trial usually, and then there's, well, like I said, only 5%, maybe 10% of cases go to trial. There's opening arguments where both sides kind of goes over the basis of why you're there and what their positions are on the facts and why the case should be decided in their favor. The plaintiff's case is then presented with their witnesses and their positions and their evidence. Then the defendant's case is presented. Then there's cross-examination of all the witnesses on both sides. And then at the very end, there's closing arguments. There's a verdict at the very end from either the jury or the judge if it's a bench trial. And then the verdict includes how much monetary award there is for either party, or whether the case is decided in the defendant's position, then there's nothing. awarded, and the case is dismissed. So this is kind of a general overview of how the trial goes. So there's post-trial motions as well. If a jury's verdict is so out of the ordinary or unreasonable, there is a motion for judgment or a motion for new trial. There's a bunch of other motions as well that you could file, but there are ways to ask the judge for redress of your of the situation before you have to appeal it. For instance, that Jeffrey Feiger case, I'm sure the defense attorneys, after hearing that outlandish amount of award, like $250 million when they can only award $5 million, they probably filed a motion for reconsideration or a motion for a new trial or something like that. Then if the judge dismisses any kind of post-trial motions, or if there's an issue of law that you have, you can appeal that case up to the higher court system. You have to have a legitimate ground to file an appeal, and it must be able to claim that the lower court committed an error of law. So there's also, I don't know if a lot of people know this, but most everything is electronically filed in circuit court, district court, some other courts, federal court. The place that I've heard that isn't electronic still, and it's pretty old school, and you have to actually physically attend the court to file anything, which is very time consuming if you know how to, if you can imagine like driving to a court system just to file something when you have 100 other cases that you're working on. It's the immigration court system. They do not have any electronic filing at all. So, and that's a federal court, limited jurisdiction court. Immigration is very specialized. So they have not changed, is what I've heard. So right now, a lot of courts are hearing cases or motions online. Some decisions are posted online as well. You get a decision emailed, or you have to actually log into the system. Every case is you can find online, and it's a public record. So if you ever are curious about a case, you can look it up, and it's all public knowledge. So that's why a lot of newspapers know about evidence or what's happening with people's personal lawsuits, because it's all public. You can't be hidden. Same with probate court. Let's say a really rich person dies and there's a bunch of disputes about where the money goes. If they file a case in probate court, that is all public information, and you can locate it online. So that's why a lot of wealthy individuals want to avoid probate. They don't want people to know how much wealth they have, or how many properties they own, or how many jets they have. So that's why they try to avoid probate court, because it's all available to you. The cyber court is kind of a new phenomenon. Some courts are only taking place on the internet. I don't know very much about this, but you know, it's not happening that often. And actually, I heard that all jury trials have come to a standstill right now because they can't have trials online. So there's a lot of backlog of cases right now in the circuit court and district courts. So I just want you to remember that litigation is very expensive. Litigation meaning suing someone in court and waiting those 2 years to actually go to trial, if you even make it to trial. There's a lot of attorney time. There's also a lot of waiting on the decision. So, you know, time is money and money is time. So litigation is expensive and time consuming. A lot of business persons are turning to alternative dispute resolution, which is also called ADR. A lot of people just say ADR. It's a lot easier. These are the three ways to settle a dispute in ADR. There's negotiation, there's mediation, and then there's arbitration. So a lot of employee contracts has a provision that says if there's any dispute between the employee and the business, it must be decided in ADR. This is because it's cheaper for the company, and usually they can pick a judge, usually a retired judge, to decide their case. Sometimes they're business-oriented judges, so they can kind of handpick someone. It really kind of puts the plaintiff at a disadvantage. They're usually not as plaintiff-oriented, some of these mediators or arbitrators, but they could be. So it's really hard to generalize, but a lot of businesses just really like ADR because it's cheaper. And you know, a lot of people don't like it as much who sue a business. Individuals don't like it as much because they want their day in court, and they feel like it's not a fair system as much. But really, it's a quicker and easier way to decide a matter. So there's negotiation. In negotiation, the parties come together with or without attorneys to represent them and try to reach a settlement. Mediation is more official. It's when the parties themselves reach an agreement with the help of a neutral party called a mediator. Usually the mediator is a retired judge, which makes it more legitimate feeling because they have the background and knowledge of what kind of case you have and how much money it really should settle for. I've done mediation hundreds of times, and it's always a retired judge, at least in my circumstances. And they usually try to press you to settle because they know that the businesses could walk away, and then it would cost less. And then at least one business would either get some money and feel a little bit redressed on their issue that they had, but it also would save them more time and money with their attorney fees. So it's a good system, but it doesn't always work because sometimes businesses or people are determined to go to trial, and mediation can be, case evaluation and mediation can be ordered by a judge just to see if maybe there's a possibility of settlement. And so if a business is certain it wants to go to trial, it's kind of a waste of time. So that's just what my experience has been. The mediator proposes a solution, but it does not make a decision resolving the matter. It's just a way to kind of negotiate again, to settling the case, but not requiring you to settle. Then there's arbitration. Arbitration is a lot more formal. It's when the parties submit their disputes to a neutral third party, an arbitrator, who renders a final decision. However, the decision may not be legally binding depending on the circumstances, but like I said, a lot of employee contracts for hire say that the arbitration decision is final in that contract. So if that's the case, then the decision by the arbitrator would be final, and that would be the decision. The providers of ADR services are government agencies and private organizations. It could be anyone, but the people that the attorneys that use ADR always go to usually retired judges because they usually have a better take on any case. So Exhibit 2.4 goes over the differences of negotiation, mediation, and arbitration. So take a look and please read that. And that's the end for Chapter 2. But just to go over, some optional material that's very timely. I know a lot of people are talking about the case that went to the U.S. Supreme Court between Texas and then a bunch of other states. Texas was suing the other states for their voting. I don't know all the details, but just saying that their voting system was not intact and legitimate. So the US Supreme Court just decided recently that Texas was found to be lacking standing. I know this brings up a lot of emotion for some people, this particular situation with the presidential election, and but this is just to look at it from a attorney's point of view, or you budding business law experts, to understand that you need certain things to get into federal court. And in this case, the issue was, does Texas have standing to sue these different states about their particular states' voting situations? And the US Supreme Court said that Texas did not have standing because they lacked an injury. Texas was not directly injured by any of these voting procedures or circumstances. So it lacked standing under Article 3 under the US Constitution. So this is a good video kind of to go over what standing really means. It's just to learn what standing is and why you need to be injured yourself to bring a case. And how a court, if it redressed your issue or addressed your issue even, you would get legal, you would be found whole again. An injury is very important to have to bring a case. So either a breach of contract for a business, or you know, if you're in a sole proprietor or a proprietorship or some kind of corporation, whether, you know, or even if you own stock in a company, that there was shareholder oppression, and that's why you're bringing the case, because you actually own the stock and so you had an injury. There's all different ways the injury could be, but you need to be directly affected. And so take a look at this video if you have time. It's not required, but it might help you understand. So, all right, so thanks so much. That's chapter 2, and there are a few assignments due by Sunday. And so I look forward to receiving them and hearing more about you in your introduction. So take care and have a great week, and let me know if you have any questions. Thanks.